Your Honor, I believe it is 101.39.
All right.
Excuse me. Doesn't matter. And actually, Mr. Donovan points out it may be a civil instruction, but never the mind, it's what's happened here, and we would request it.
In 101.39, in the criminal instruction, pattern of instructions is lack of unanimity on principal, charge, reasonable effort. I am familiar with spoliation, requests for spoliation instructions, or if the court's the fact finder, to actually have a finding based on spoliation, an adverse finding to the party that if it has convinced the court that spoliation has taken place, that is an option that the court has. I particularly ran into it with, I've told y'all this before, domestic sorts of cases. Somebody destroys the computer that has all the financial or other incriminating or potentially incriminating, just destroys it. And so one side says, in view of that, you ought to find that the person is responsible for outing. Say make a specific directive or order or finding based on that. I'm not, your request on spoliation, to the extent it would bleed over into the criminal case, is, what is your specific request?
Well, my specific request is that I'm able to point to the jury instruction that if the city allowed evidence to essentially, for the mobile display data computer, they only keep it for a short period of time. Sort of like the 911 information, the state law requires that they can let go of the audio after 30 days, the city keeps it for 60, or getting on 3 years out. So when Lisa Williams files a written motion to preserve evidence, and that's not done, and
what you're requesting an instruction that
the failure to preserve the SUV in a state and the mobile data computer messages, that any inference of lack of that evidence be directed against the state. So just as in the civil cases, when, as Your Honor is explaining about the computer, this is a computer, and in the Rodney King case, it's right in the, I believe in the Pella cases, those messages, those officers were talking about playing baseball with Rodney King's head in those text messages. So those are some pretty important messages when you have angry officers that are armed and are in a manhunt. So the lack of those messages, to have a specific instruction saying that the lack of those messages is inference against them and whatever that they may draw from that. Same thing with the SUV. This is a serious case. My client is facing decades in prison. And that's why we've been doing what we've been doing here and taking care and doing what we need to do to ensure that the Constitution is constitutional rights of my client are afforded. But in this case, for whatever reason, that request was not passed on, whether it's the DA's fault, whether it's the police chief's fault. I don't see the police chief here. But in any event, I see a lot of other folks with weapons and uniforms, and I'll take that up after I make this argument, Your Honor, because it goes back to a prior motion in limine. But that spoliation motion, that inference should be that should be held against the state. That we couldn't test it, we couldn't get photos, we couldn't do things that we could do. And then to add to this, the problem, they can choose to put whatever evidence they want on there, but they got the outside of that SUV So they're not even showing the inside. So the inference of letting that evidence go by the wayside should be against them. Same thing with the mobile data computer. And it's not like we didn't ask. I asked what I could ask. And the officer said, well, that's not my bailiwick, but yes, there were messages flying, but they weren't mine. I can't preserve it. Well, someone higher up, got some folks in white there that may know the answer, but in any event, we're beyond that now. We're going to the jury, and I asked for a spoliation instruction as to the SUV not being preserved and the mobile data computer messages not being preserved.
Thank you. Ms. Ellis?
Your Honor, I would state to the court, just to clarify, that pictures and that crime scene analysis was done on the SUV. Those photos were turned over to the defense, so I don't believe that there's a proper ground for that, and that the crime scene was processed with due diligence. Your Honor, furthermore, the data transfers, I've never heard of them being called in or requested or anything like that. Furthermore, Ms. Williams's request for keeping all of the evidence and preserving that was made after they had already processed that SUV and returned it back into service as a police vehicle. Your Honor, I just simply want to put that on the record, and I state that this is not made in the best of faith.
The motion for a spoliation instruction is denied. There are certainly credibility and reasonable doubt issues, among others, that potential that could be argued as to where the evidence is, and because it's not only reasonable doubt, it's not only it also deals with the lack of evidence. And there's an argument as to lack of evidence. Not only that evidence presented doesn't lead to a conclusion, but the lack of evidence supports that. So the spoliation instruction requested is denied. All right. Anything else before we bring the jury back in?
Yes, Your Honor.
Chalmers.
Mr. Donovan attempted to file, stamp, and bring up here a couple different motions and filings, and the clerk claimed this is hearsay, but he could speak to it, that this original signature on top of copy was not original and they wouldn't take it. Here, with the use of the Sharpie, I have an original signature on another filing, which the clerk on the second floor wouldn't take. So it's getting curiouser and curiouser about these things. So I guess I would ask that we could file this here, so whatever's going on down there doesn't happen. I may have a very bad signature because I'm left-handed, but it is the original signature. And I guess I just haven't seen this before with folks refusing to take filings. So I just want to put that on the record and inquire of the court what you'd like me to do.
What I would like for you to do?
Well, I'd like to file these, but
Oh, yeah, well,
I know what you'd like me to do, Your Honor. I'm a mind reader, but
so you got some documents you want to file?
yes, Your
Yes,
Honor.
sir.
You're
Come on,
on.
sir. Hang on a second. Yeah. Oh, okay. All right. So you got it stated right. All right. Well, you've got some documents that you want to file. We can file those right here in the courtroom. You have a file stamp here in the courtroom. All right.
Your Honor, which is why Mr. Donovan went downstairs. I don't know what the trouble is, but a hand signature would be fine with me. It'd be nice to get them file stamped. If you want to wait a minute, I'll go down there and
What are the
Yes, Your Honor.
motions?
You asked me to put in writing the motion to dismiss on constitutional speedy trial grounds, which I have. Someone's working on a little memo. It's real brief. It's 2 pages. It just basically states the facts as Your Honor recounted them about the motion to continue. The second part of the motion is the motion for sanctions against the prosecutor, with the remedy being requested that they apologize to my client in open court at a time to be determined. And the other filing is the second affidavit in support of the motion for sanctions against the prosecutors. It's an affidavit of former Judge Karen Faye Shields. The other affidavit was from Stuart Fisher, and it also included my CV. So those are the 2 filings. The only one that would make a difference now, if I could hand those up. And then,
If you'll bring them up here, let me look at the signatures. You say you signed and attested, I'll put a note on them, and somebody can take them down to the clerk's office. All right.
also,
Coming up.
the sense of smell might indicate the Sharpie on that one. It is sloppy, which I would stipulate to this one. If I could give a copy of the file stamped with mine, hard copies, and I could serve the opposing counsel with copies.
These 2 documents presented to me in open court, I've reviewed it, they now meet the criteria for the attorney to sign them without there being a question. So I just put a note that it's okay to file now. If we could file those and put a file stamp, and that'll remedy any issues, I would think. Be right with you. And this one also, there are 2 of them that all right, we'll have those filed in just a minute and have a file copy for you. Anything else?
Yes, Your Honor. Pre-trial made a motion about officers wearing their uniforms and bringing their weapons in here. And as you can see, and I'm stating this for the possible appellate record, that a lot of these folks, just based on eyeballing, have not been here. Some of them may have been here. But now we have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 police employees or folks. I suspect, I don't know for sure because I didn't search them, but I suspect some of them have sidearms, and this was exactly the motion I made earlier. As I stated in another case, in the old courthouse with Judge Allen from Alamance County, I made a motion. Actually, in that case, every seat was filled with uniformed officers, and this was really what I mentioned pre-trial was probably going to happen in a political case as this in Durham County in 2015.
Thank you. The motion continues to be denied as it was pre-trial, but we've got it on the record now.
Thank you, Your Honor.
Thank you. Any other matters we need to address?
Your Honor, the state has filed, I believe I gave a copy to you. There's a copy that was filed this morning. A copy was given to Tarkisha for filing. A copy was given to Mr. Donovan and to Mr. Charnes. That is a motion in limine to limit the counsel's remarks during closing argument. During much of his colloquies with the court in this case have dealt with cases that I believe would be improper to be part of a closing argument, such as Huerta case or involving former DA Michael Nifong. Furthermore, this case also deals with several issues that have been previously dealt with by the court, and we would ask for limiting instruction on him referring to this as an illegal stop when that has already been determined, or any other determinations that have already been made by the court. Your Honor, that would simply be the state's requests to limit those remarks. And as you can see, the is based on North Carolina General Statute 15A 1230, which basically A states that during closing argument, the jury, to a jury, an attorney may not become abusive, inject his personal experiences, express his personal belief as to the truth or falsity of the evidence, or as to the guilt or innocence of the defendant, or to make arguments on the basis of matters outside the record, except for matters concerning which the court may take judicial notice on. Attorneys may, however, on the basis of their analysis of the evidence, argue any position or conclusion with respect to those matters at issue. Furthermore, Your Honor, we cite State v. Whiteside, which is 325 North Carolina 389, which states that the notion that the scope of a counsel's closing is not unlimited, and the presiding judge may limit the argument in the exercise of Your Honor's discretion.
Thank you. Mr. Charles, you wish to be heard on the motion in limine, the particulars of the motion in limine filed by the state.
Yes. At the outset, I will say goose gander. So everything that they have in here, I don't know who the goose and the gander is because I'm not really familiar with those terms, but I know.
Animal husbandry is what you're.
Yeah, I went to Michigan State for 1 year and they just never taught me the difference. So my education was hampered in that way. In terms of arguing about the motion to suppress, I know Your Honor's ruling. And as Your Honor had pointed out, everything from the percentage of stops by this officer of African Americans and what a jury might believe that to be, that's for argument, what they believe the testimony was. As to the Fourth Amendment, as to the Constitution of this United States, North Carolina, as well as case law, the case law says I can argue those things. I can argue that officer can't use excessive force. I understand the jury instruction doesn't mention that, but the Fourth Amendment is our law. I'm not going to make an argument that it was an illegal stop under the Constitution, but our laws allow and the Constitution requires me to defend my client, and to do that, in this case, mentioning the Fourth Amendment, mentioning that the officer cannot use excessive force is arguing from the case law and the Constitution.
What would you be offering that argument for except to put into the jury's mind what I just said I would not instruct on? What is the purpose of that other than, you know, I ruled, what I ruled, right or wrong, what I've ruled in this case is that the instruction on self-defense and excessive force will not be given. That I guess I needed to say that they should not be argued. Just so you put that on record. What other purpose would you be arguing the Fourth Amendment for other than to say that my client defended himself.
No, that's not, I wouldn't say he defended himself. I'm stating the constitutional ruling and the protection that the Fourth Amendment affords that an officer cannot use excessive force.
But to what end does that statement go?
It's arguing the law. It's not arguing.
You can argue the law that the speed limit is 55. That's not what where does it lead to in this case other than to argue something that I have ruled is not going to be instructed on. Now, I'm instructing them on what I think the law is, right? Again, right or wrong, what the law is here. If you argue that, you're essentially arguing it seems to me, what I just told you the law was not applicable to this case. It limits your argument. It certainly preserves your right on, if it ever even got to the point of appeal. That's what the jury's going to do on this. That's why we have juries. But I'm having trouble understanding that you can argue excessive force after I've sort of said excessive force will not be an instruction to the jury. I'm having a struggle with that.
Yes, Your Honor. The issue of the limitations on a government official here, a law enforcement officer, it's a statement of law that is true and has been going back to the time we became free people, that an officer cannot use excessive force. So it's not in your instruction. It's a true statement of law. And if I go out of bounds in my argument, of course, it sounds like what the ruling is, I can't mention the Fourth Amendment to the United States Constitution. And if that's the
ruling...
Not
just leading to being contrary to what I just ruled, the law applicable to this case to be, right or wrong, what the law I find to be applicable to this case. If you argue something that's contrary to that ruling, I have some difficulty with it. And I don't hear a compelling reason of some other use for that argument other than to countermand what I just ruled was not going to be the applicable law for the jury to apply in this case. That's what my concern is. Now, we're having a sort of like a law school back and forth here. So
well, I appreciate that.
For those who don't know, we do this all the time. But that's what my concern is.
Yes, Your Honor. I understand that the right people to be secure in their persons. And person is the right not to be killed. It's the right not to be killed. So the Fourth Amendment says it's a limit on the government. You can't shoot a fleeing person in the back unless they're a murderer and they're armed. Here, you got a moving car. The Fourth Amendment applies in many places, whether Your Honor instructs on it. I understand you're not instructing on it. So in some respects, it's dangerous to talk about something you're not instructing on, because then they go back. Say you let me mention the Fourth Amendment, and then an officer can't use excessive force. Then the jury comes back and they look at the jury instructions. Well, where is that in there? And they say it's not in there. So that's risky in some respects, but that's my issue as to my client. But there's so many places in this case that the Fourth Amendment could be argued. The general order about not chasing, the underlying basis for that, I believe, is you can't shoot someone who's running away from you and is unarmed. There are aspects to this case that it's so complicated in this jury instruction, the pattern instructions can't possibly deal with these issues. So to limit my argument about what the Constitution says, in essence, from my perspective, and I mean no disrespect, is we're banishing the Constitution from my arguments. And my arguments, as Your Honor knows, and sometimes they're not always welcome, but we have good conversations about the Constitution, which I appreciate, is the Constitution is living here. It's living here right now, and if I don't get to talk about it, it just compounds the issues that might be on appeal if there's convictions. So the Fourth Amendment applies here in many respects at each point along the line. Not just on the stop, not just as to whether there's self-defense or excessive force towards my client, but this officer can't use excessive force. And for me not to be able to state a legal truism that actually applies here from my perspective, again, I would argue it's reversible error. I'm glad we're having this conversation because I'd rather not be interrupted during my open or closing, just as they'd rather not be interrupted during their closing. So I'm glad we had this conversation, and it sounds like I'm going to be sitting down and not being able to argue about the Fourth Amendment, that it limits what an officer can do, but it's part of what they're finding. And I understand you're not instructing on it, but it's pretty important. And all I can say is I don't see how I can't argue that the Fourth Amendment applies to my client in this day and age in this case. I don't know, but evidently I haven't done a good job. I'm circling around, so I'm going to sit down. But it's an important argument, and I understand you're not instructing me, but it's a simple, tiny piece, but important piece. Because the Fourth Amendment is the fulcrum that leads to all our other protections. We have no protections here if we don't have that protection. And to not be able to argue what the case law is, not in derogation of your jury instructions, it's simply to state a legal truism. The officer cannot use excessive force. And then they'll look at the jury instruction and they'll do whatever the juries do. But I don't know how to argue it any better than that, so I'll sit down. Your Honor can rule. I do have some other requests that are in line with this motion in limine the state had made about my argument. I have some things of concern that I think they're going to argue, but I'll sit down now and let Your Honor rule, and then I'll stand back up if that would be okay.
Yes, sir. I would assume that all of the attorneys here are veterans and experienced. Would understand that we cannot bring in matters outside of the record. And I took Mr. Charnes's references to the Huerta case and former DA Michael Nifong and some other ones that he referred to, as all of which was outside of the presence of the jury, as offering a perspective to the court and as to a basis for why he was asking for the relief he was asking. I didn't take them to be anything more or less than that. He was arguing a point. He referred to some matters, all of which were outside of the presence of the jury. And he referred to not just cases in the appellate court, but cases that he personally was aware of. We had a book. We had some motions in which there were comparisons drawn using local references or to cases or DAs or whatever. I consider that part of this establishing the basis. I would assume that everybody knows that we can't argue that to a jury. That you can't, the state can't say, well, in this case it happened over in Wake County with the same fact situation, they found the defendant guilty of this. That wouldn't be appropriate. Neither would defense counsel saying, I made this case over in Wake County in the same situation, found the defendant not guilty. That would not be appropriate. We're basing our evidence. I mean, I'm talking to the jury all the time about they can only consider the evidence they have here in the courtroom, and that all the evidence that they will have to consider will have been presented in here, inside the courtroom, in trial. And references to, it gets a little gray because if you're saying George Washington or Benjamin Franklin did something, it's stands for freedom and equality and fair play, and that's what we're just carrying the forefathers' words. That's not really too much of a fudge or anything like that. On the other hand, if there's a local matter that created, or it could have been a national matter actually, that creates emotions or engenders comparisons to things outside of the courtroom with the jurors, that's not appropriate. I have to depend on y'all not to cross that line, but you have great flexibility on what you do argue. This other case and the former DA, those are matters that I would think that we shouldn't argue. I don't know that there's a motion necessary to tell you that. It's just that that's where it all will be. And the statement's correct that the last thing you want is you're making the argument to the jury, objection, sustain, you're right, you've lost your momentum, you lost your flow, you don't know how the jury interprets those sorts of things. Yeah, I tell them not to consider it, but that's up to a jury. So we have, the jury has to base its decision on the evidence here or the lack of evidence here. The attorneys argue inferences based on the evidence that was presented or the lack of evidence was presented, and we can't bring in outside comparative matters. That have a sort of a substantial impact on the jury's jobs and impartiality and ability to stay fair and impartial. So I would think that part I don't need to address. As to the Fourth Amendment matter, Mr. Charnes, I also have to base what my decision here is on what the law that I believe is applicable based on the evidence, and that's evidence, positive and negative evidence that was, and I don't know who positive for whom or negative for whom, but just all the evidence as to what the issues will be and what the instructions should be. And it's my, I put on record, it's my determination based on what was presented during the course of this trial that the excessive force instruction was not called for, not based on, I don't know what everything that happened, but what I know is what I have to base it on what the evidence in this case before the jury may be. And that I ruled that excessive force was not an issue to instruct the jury, and therefore I also would rule that it's not one that can be argued. And but I think it's important for me to put that on the record for preservation, if nothing else. It's similar to, you know, the decision that the evidence, and I struggled with it, but the evidence did not call for, in my observation, a self-defense claim, and therefore a self-defense instruction, and therefore we can't argue about self-defense. So, let's make one last thing clear, is that I mentioned this to the lawyers. You know, the Constitution is like the most valuable document on earth. And it provides us with rights. It gives us some responsibilities too. But I measure everything by the Constitution of the United States and the Constitution of North Carolina. You know, when a court rules something's unconstitutional, that means the General Assembly or the local city council or county commission, what, they make this rule, this law, but that's not the end all be all, because it has to pass muster with the Constitution of the United States or the Constitution of North Carolina. And so when a judge declares something unconstitutional, it's not because he doesn't like the law or does like the law. It doesn't matter. It's does it pass constitutional muster. So I just want to emphasize that constitutional rights are important things to me. I enjoy them. I get the benefit of them, and every person in the United States of America, and in this state of North Carolina, and this county of Durham, and in this city, should have those equal opportunities. However, based on the evidence I've heard in this particular case, my ruling is that that argument is not to be made. Now, there was additionally a request, a motion in limine filed by defense to prevent prosecutors from talking about dangerousness of the officer's allegedly missing weapon in closing. That was also a matter that was filed yesterday. Mr. Chalmers,
Yes,
to address that.
briefly, to avoid the interrupting and objecting, to get your Honor's thoughts on this. Some arguments that have been made during motions hearings in terms of the dangerousness to the public, issues about little kids finding the gun. The gun has not been recovered for whatever reason. And I will note for the record that in discovery there was another officer's gun that was missing. That in this case, I believe they thought they found Officer Stewart's weapon, but it actually was a service weapon that was lost by the officer. And
Lost by a different officer?
A different officer. And then there was a snitch that was going to testify and then was kept in the Durham jail and didn't testify. But in any event, this testimony, it's unduly prejudicial to, he's not charged with the gun that's out there. He's charged with the things he's charged with. And so to talk to the jury about the dangerousness of this weapon being out there would be unduly prejudicial, and I think it's appropriate, just as we've talked about what I do, we talk about that. Also, we talk about the knife that was found. One of the CSIs didn't even know whose house it was found in, so we don't get an argument, oh, that knife was in the car, because there's no evidence whatsoever whose knife that was. There wasn't any forensic evidence in this case, as Your Honor knows. There wasn't DNA, there wasn't fingerprints, there wasn't even gunshot residue evidence. And so I don't want to be objecting to the implication that there was some weapon in that car when there absolutely was no testimony there was a weapon in that car. That car was on. The officer was felt very comfortable with a vehicle running.
And we're talking about that, there are a couple of cars that were involved, the maroon car and the black car.
The maroon car, and then there was a knife which was never associated with any particular person. So what
that was alleged to be in which car?
Either in a car or in the house. I believe in the black car. Okay. And that wasn't my client's car. They didn't do any forensics on it. So what I want to do is just peremptorily talk about this whole issue of the gun and the unduly prejudicial nature of talking about the dangerousness of gun out there when that's not what he's charged with here. He's charged with the things he's charged with, which are appropriate to argue whether he's guilty or not guilty of. Same thing, that knife. There's nothing that ties that knife to him. There's no forensics, and so the argument that somehow that knife was in the car, the burgundy car, the maroon car, would be inappropriate. It's unduly prejudicial. So just as each side is bringing up their fears or thoughts about each other's closing, I bring that up.
Thank you. For the state, anyone?
Your Honor, just briefly, the weapon and its loss is an important part of this case. I don't think it's unduly prejudicial for them to know that the officers responded in this manner, and that there was a weapon that is gone and that is still out there.
What about the knife thing?
Your Honor, we had no intention about talking about any knife.
The question is whether you say, yes, the gun was out there, and to the jury, the gun was out there, the gun was stolen, the gun was whatever taken, what was used in a robbery, whatever it is. That seems to be a separate issue as to whether that creates a public safety issue.
Yes, sir.
Apart from the fact that it's the subject of what is alleged to have been a robbery using a gun, shooting using a gun, where the gun was involved, more like, accurately, or that the gun wasn't found. That motion is allowed.
Your Honor, I just want for clarification, it's not the state's intention to inflame the public or the jury with the dangerousness of the weapon, just to make references to the fact that it was stolen, that it is still out there, and that's one of the reasons why they did take the actions that they did.
Well, that gets to be a slippery slope, that last little part about whether the mere fact it's gone, does that mean, does that create a dangerous situation for the public
Correct, and without stating that to the public, it's still the state's duty to show the elements of the crime and the permanent deprivation of that weapon, and showing that it's still out
But you
there.
can show that without saying, you know, it created a danger to the public. You can show this gone.
Correct,
And it was
and that's
never
what-
recovered.
That's what we intend to do, is not to say, like, we intend to
That,
say
I
it's
think we're
gone,
fine.
but it's not.
That's all he was asking.
Thank you.
And that's, I think if we're on that, wavelength, that is, I think that we have a common wavelength. Any other matters?
Your Honor, I guess to talk about it now, the jury will come in, we'll rest, and then jury sent out, we'll make a motion to dismiss. Before I start my closing, I would like all the exhibits, and it seems like a good place, an hour, so I can use them on that table, just procedurally, since the jury's
Can we just-
out.
Can we go ahead and do that?
I would
now?
love to do that.
And
So-
just have them out. But here's what I envision is that I bring the jury back in, ask Mr. Charnes, I said, state having arrested, will there be evidence for the defense? He'll answer appropriately. Then I will say to the jury, members of the jury, all the evidence has now been presented. It will soon be your duty to decide from the evidence what the facts are, and to apply the law that I'm about to give you to the facts, arriving at your verdict in this case. Prior to the summations of the lawyers, I'm skipping a little bit here, but I'm required to confer with the lawyers about the law involved in the case. Usually that's a charge conference being referred to, but the law involved in the case here is you want to make your motions, and the jury has to be out to make that motion. And I'll tell them we'll have them back in 5 minutes.
Your Honor, just since we've been talking about the Constitution, some people say defense rests, some say no evidence. What I'm going to say is defense rests on the Constitution of the United States. Thank you.
All right, if we can take a moment to get those exhibits on over there so that when the jury comes back in, we won't, we'll kind of get them in a rhythm. Two. And we've got some large exhibits and some small ones.
Your Honor, I'd also like our exhibit marked for identification. Obviously, it's not an evidence, but it's closing, so I would like those as well. Thank you.
You're going to, I only have one exhibit from the defense, Mark. That was the general order. Are there more than one?
No, the bias-based policing and then the transcript. This was the transcript of the April 20th, 15 motion to suppress, which I used with the witness.
Your Honor, it's my understanding those are not introduced in the evidence.
They aren't. This is closing argument.
You're intending to read from that, or
To read
exhibit?
the transcript, instead of going from memory, I'm not going to read it as an exhibit. We can take the exhibit, mark off, but I intend to read what his answer was because that was his answer.
And that was his answer from the stand.
Yes.
You're not going to go into things that were not asked of him and he answered about on the stand.
Yes, sir. And this was his answer. This is what he said. And he said, yes, he read it.
Well,
If you take off the exhibit, so it's not confusing, I guess we have to leave it on, but we didn't put on evidence. So I'm not going to display it to the jury, but I don't want to go from memory. I want exactly what was said.
That part I don't have any issue with. I will, if there are references to I got the transcript or something like that's the equivalent of publishing to the jury though. So if you're just saying, you know, at a prior hearing, you heard him say, and that's it refreshing what it is, the jury's recollection will decide whether that's what they recall the question and answer to be. Likewise with the other general order, I believe you've got the general order. If you read from that, it gets stickier because that was not an exhibit, and they did not quote it verbatim.
Yes, Your Honor.
So if that's the sticky point that I want to do to make sure that we're not doing that. And there was a valid, very fundamental reason for identifying them and for not putting them in evidence so that you could preserve your right to have open and closing final summation.
But I think the name of it, the general order number, which I don't have committed to memory, which I should, but I don't. So I will not read from it.
You see what I'm saying?
I see.
And then, so anyway, that's good. Do you have all the exhibits you need over there? Or
I'm just collecting them up.
all right, well, go ahead and let's get those, and then we'll bring the jury in.
While I'm arranging this stuff, another motion would be eliminated about those medical records. There was no medical testimony, not even a nurse, not a PA, not a doctor or surgeon, and I would object to the state asking those folks to be medical personnel. Reading that, generally what I've seen is medical records are put into evidence, and then the doctor, the surgeon, the nurse, the medical staff uses them to refresh their recollection. They testify about all this was done for medical care, and then they get in what they need to get in. None of that was done here. So we have a stack of medical records that, while they're kept in the course of business, they haven't, the further steps have not been taken. So I oppose reading in closing from those records that we haven't went through those extra steps.
Thank you. That motion is overruled.
Yes, Your Honor.
Thank you. All right, for the court's information, I'm working on the jury's copy of the instructions, and then I'll get you the verdict sheet information here forthwith. Thank you, Sheriff. If we could have the jury return, please.